Commissioner Yaki, I would only add this, only because I have a little bit of familiarity with, I think, an analogous statute here, the National Labor Relations Act. Under the Act, there are so many instances of conduct that is construed as intimidation in the voting process when people vote
Sure.
whether they want to do it or not. Many of the items that you've been providing by way of illustration would be considered violating Section 8A1 of the National Labor Relations Act. And this also goes to Commissioner Thurnstron's concerns about what is intimidation under 11B. Well, I think what is illuminative is looking at what intimidation is under the National Labor Relations Act. And it's fair to say that you can draw an analogy because you're talking about the right to vote, whether it's to be part of the union or not to be part of the union, or to vote for whatever candidate is on the ballot.
Sure. No, I appreciate it. It wasn't meant to pin you down. I just was asking because
Commissioner Yaki?
circumstances come up. Thank you very much.
Okay, Commissioner Melendez.
Yes, thank you, Mr. Chairman. Just one comment or something, anybody can answer this. I know that, the comment that we weren't really talking about intimidation of a voter because we're not really specific. We don't have a witness here of a voter that's saying he was intimidated against. But then even going to the poll watcher, of which Mr. Bull talked about, we don't even have that person here who would speak for himself. I've heard other people speak on his behalf that he was shaking in his boots or whatever, but it would have been great if we would have that person here testifying on his own behalf since he was the person that was intimidated against. So
my understanding is he lives in that district, and testifying in front of this commission when he lives in that district just didn't seem to be in his best interest. Now, I don't know if that's necessarily the case, but that's how it was conveyed.
And unfortunately, in courts, whether or not you're there to testify really has a lot to do with whether or not,
Sure.
With this whole case. Thank you.
Okay, Commissioner Harriet.
Mr. Hill, I just wanted to clarify with regard to the Phoenix hypothetical that Commissioner Yaki was used. Do you regard it as being equally intimidating to be in a suit with a camera as in a paramilitary outfit?
No.
With a
And that's...
Could you expand on that a little?
Well, yeah, obviously I'm sitting in a suit right now, so...
And you look intimidating to me.
Yeah, right.
But not to me.
Army infantryman. So, absolutely not. The way the hypothetical was set up, though, I could see someone being intimidated and agree that, yes, that could potentially be intimidating.
So there may be circumstances.
Right, could be. What was not a hypothetical is the fact that two men standing outside of a polling place in Philadelphia wearing paramilitary garb, one of them armed with a weapon directly in front of a door that people have to pass by to get into, is intimidating to a lot of people. And, I mean, we witnessed it personally.
Commissioner Gaziano.
I want to thank the witnesses again for your patience in testifying and coming down today. And I will state for the record that both Commissioner Yaki and I are also in dark suits. We sometimes say things to each other that aren't the most friendly, but I hope I don't intimidate him, and whether he tries or not, he doesn't intimidate me.
You've never intimidated me, Mr. Gaziano.
Okay, thank you. Now, may I ask, for point of personal privilege, if we could take a 5-minute break before the next witness?
Yes, so you've concluded your questions? Okay, gentlemen, thank you very much. Your testimony is quite important. Okay, we're back from the break. We are pleased to have with us today Gregory Katsas, who is the former Assistant Attorney General at the Department of Justice. Mr. Katsas, please raise your right hand. Do you swear and affirm that the information you're about to provide is true and accurate to the best of your knowledge and belief?
I do.
Very good. You may proceed.
Thank you, Mr. Chairman. My name is Gregory Katsas. I'm a partner at the law firm Jones Day. I served in the Justice Department between 2001 and 2009. As relevant to this proceeding, I think my most relevant experience was serving as Principal Deputy Associate Attorney General, the top advisor to the Associate Attorney General for about 20 months. And for about 8 months, I was the Acting Associate Attorney General of the United States. I was not in the Associate's office during any of the deliberations about this case, so my testimony doesn't implicate any privilege issues that some of my successors might have. I've submitted written testimony to you. I won't belabor that. Just to summarize my conclusions, I was asked by Chairman Reynolds to opine on the decision-making processes within DOJ and the level within DOJ that decisions to file or change course in this case would have been made. My conclusion was that the decision to file the case and to change course could not have been made below the rank of Assistant Attorney General for the Civil Rights Division, and would have been made with at least consultation by one of the department leadership officers, most likely the Associate Attorney General, if not someone higher up the chain than that. With respect to the merits of the case, I was asked to evaluate the complaint and give an opinion on the strength of the case, both in terms of the decision to file at the outset and in terms of the decision to abandon most of the government's claims in the case and narrow the requested injunction, notwithstanding the default. I did not have any independent knowledge of the facts of the case. In the written testimony that I gave you, I was asked to assume the truth of the allegations in the complaint, which I did, and my conclusions were that the complaint stated a strong case of voter intimidation against all the defendants, and that the decision to file was fully justified, and that the decision to abandon most of the claims in the case and narrow the requested injunction was not justified. I was asked to attend the entire hearing and watch the evidentiary presentation that you all have heard. Based on that submission, my opinions remain the same. Indeed, they are reinforced. I think the evidence that you've adduced today tends to confirm both the intimidating nature of the conduct that took place in Philadelphia and the connection between the Philadelphia conduct and the National Party. And I'm happy to answer any questions.
Thank you. Vice Chair Benson?
I'd like to pass for the moment, but reserve the right to come back.
Very well. Commissioner Krishna?
Thank you, Mr. Chairman. Mr. Katz, is there a de minimis level of voter intimidation or a number of intimidated voters below which intimidation becomes acceptable under 11B?
No.
Is there any difference in your mind in terms of whether or not there would be an actionable case of voter intimidation under 11B if a defendant brandishes a weapon? In other words, is a predicate to an 11B violation the brandishing of a weapon?
I think brandishing a weapon would be certainly sufficient to establish intimidation, but not necessary.
Is there a heightened standard at all? There may not be any case law with respect to this, but in terms of the manner in which justice would assess bringing a complaint under 11B differ if one of the alleged defendants was a credentialed poll watcher? Is he held to a heightened standard?